Interest in ESG has never been higher, and the pressure is on for investment organizations to move toward the sustainable investing model. As the world shifts from ESG investing as a good idea to ESG investing as a reality, it's becoming increasingly important for investment professionals to stay abreast of ESG trends and educate themselves on ESG factors. From institutional investors to retail investors, ESG is top of mind and growing. In the first half of 2020, the Principles for Responsible Investment (PRI) signatories increased by 28%, and the assets under management grew 20%. 90% of investment professionals expect their firm's commitment to ESG will increase, citing the need to manage risk and respond to client demand. Still need proof? The influence of ESG ratings on firms' cost of capital will only increase in the next 5 years. And let's face it, only 5% of investment professionals say there is nothing that would convince them to start considering ESG issues. Are you prepared for the rise of ESG?
Good afternoon, everyone. Welcome to the Investor Series, an introduction to estate planning webinar. Thank you for being here today with us. My name is Monzen Carlo Malyari, Market Data Manager at Citi Philippines, and I am your host for today's online event. We would like to take this opportunity to recognize our annual corporate sponsors, silver sponsor FTI Consulting Philippines Incorporated, and bronze sponsor DNL Industries Incorporated. To formally welcome us all, may we please have the President and Chairman of CFA Society Philippines Incorporated, Dr. Robert Ramos, CFA, CAIA, CIPM, RFC.
Thank you, Monzen. Thank you all for joining us. I hope that everyone is well and keeping safe. I've always believed that even during the most trying times, most difficult times, and most busy times, every individual can find ways to improve. Obviously, obtaining the CFA charter is one path to improvement, while learning from others is definitely another way to do so. In this talk, I do hope that you pick up a lot of pointers, how you can improve, especially when it comes to the area of estate planning. While at the same time, for some of you in the banking industry, you can use information that you gain in scaling up the corporate ladder. Thank you to our speaker and my friend for sharing your knowledge. Hi, Wanda, good to see you. And thank you all for attending this webinar. Back to you, Monzen. Have a good day, guys.
Thank you, Dr. Robert Ramos, for the warm welcome. Again, welcome to the webinar. This has been brought to you by CFA Society Philippines. Joining us today to talk about estate planning is someone who has been with the banking industry her entire career. She started out as a management trainee in PCI Bank, which eventually became EPCI Bank, then BDO, and finally moved on to Metro Bank. Her field of expertise is trust banking, which involves providing solutions for wealth building, wealth management, and even wealth transfer. Currently, she is the head for account management of the Metro Bank Trust Group with the rank of First Vice President. She is also a registered financial planner and has graduated at University of the Philippines, Diliman. Without further ado, may we call on Ms. Giselle Beltran or Ms. Wanda Beltran.
Thank you, Monzen, and welcome everyone. Thank you very much to the CFA Society Philippines for the invitation to speak before you today on the topic of estate planning. Much of what I will share with you today comes from my experience as a trust practitioner, having used this structure extensively as a tool for estate planning. So let me just share my slide. I hope I am clear. Okay.
Yes.
There. Thank you. So let me begin by sharing with you some anecdotes. Meet Bob and Marie, a simple couple with nothing much to their name, except for a piece of property which also serves as their family home. They have one son, Albert. When Bob turned 65, the couple decided to transfer the family home to Albert via a sale, given that the capital gains tax was much cheaper than the donor's tax or eventually the estate tax. The couple continued to live in the family home with Albert, his wife, Cynthia, and his son, Dylan. 10 years later, Albert dies tragically from a terminal illness without a will. Naturally, his estate passes on to his wife and his son. Now, the problem started when 2 years later, Cynthia, the wife, decides to remarry. Now, Albert's parents are forced to move out of the family home. Then there is the case of Doña Maria, who has a very successful business where 2 of her 3 sons work, Danny, the eldest, and Buboy, the youngest. When Doña Maria dies, naturally, the ownership over the business was split into 3 to answer for the inheritance of her compulsory heirs. Jim, not having any interest in the business, decides to sell his share to an outsider. So now there is a an outsider in the business, challenging the company and creating a lot of chaos. Then there is also the story of John, a very successful lawyer who is unofficially separated from his wife. They have one daughter, Daphne, who lives with him. Again, John suddenly dies, and without fixing his affairs. Now his wife is back, claiming her share from John's estate, claiming her share as a surviving spouse out of John's estate. And finally, there is the story of Jerry, who fathers 2 illegitimate children with a woman that he is no longer friends with. No. He decides to open a revocable trust account to pay for the needs of his children. Unfortunately, Jerry meets a tragic accident, and the trust, being revocable, was consolidated with the entire estate and was distributed according to the law on legitim. Now, the legal wife, who is also the administrator of the estate of Jerry, because she was outraged by the infidelity of Jerry, decides to get back by going to court and lowering, to challenge the share of the illegitimate children, saying that they have already received advances to their inheritance from the trust. So friends, these are just a few of the horror stories that I've encountered over the years as a practitioner, born from poor planning or the lack thereof. Remember this, estate planning is necessary for anyone who accumulates assets and intends for those assets to pass on eventually to their beneficiaries. While the primary goal of estate planning is to find the most cost-effective means to transfer assets to one's heirs upon death, it also addresses other important objectives, such as wealth accumulation, protection and preservation, providing for the desired standard of maintenance and care of the estate owner and his heirs, and of course, keeping the peace in the family. But the more progressive wealth management practitioners believe that estate planning is also about building one's legacy. Legacy planning takes estate planning a step further because it allows you to incorporate your principles, that is your wishes, your morals, your views, your philosophies and beliefs, into your plan. So, if the traditional estate planning focuses solely on your estate, which is what you own at the time of death, legacy estate planning focuses on who you are and the whys behind what you own. Thus, when thinking about what's best for your wealth, your goal does not simply end with just distributing it. Rather, you become more concerned about what you want to happen with it and how it should be utilized to create more good for you and those that you bestow it to, so that all your efforts, all your hard work, your sacrifices to build that wealth would not be in vain. And when it comes to your beneficiaries, friends, it is no longer just about leaving something behind for them. You become more concerned with ensuring that they continue with their standard of living for a very long time, that their values in terms of managing and spending this wealth is aligned to yours, and that they be able to respect your desires insofar as how this wealth is to be utilized. That the wealth you leave behind is also able to benefit future generations and even advocacies that you truly care about. So the primary goal of most estate plans is to create a roadmap for the distribution of the estate assets upon the death of an individual. A basic estate plan should have the ability to protect and grow the assets during your lifetime, as well as ensure that those assets are available to provide for your loved ones after your death. So it should include, among others, a good estate plan should include, among others, incapacity planning, healthcare planning, tax and probate avoidance, and even retirement planning. Now, when making your plan, here are the most important considerations. So I'll give you a moment to check out what's on screen. So I will not read anymore what's on screen. So these are some, there are a lot to consider, but these are just some of the more important considerations to remember. Okay, now, the first three affect your estate because other countries have different estate taxes that may naturally lower your estate's value. So let's take for instance the US. So if you are a US citizen, you will be taxed on your total worldwide estate. Okay. Now, if you own a condominium unit in the Philippines, the Philippine government will also tax you on that asset. So there you are thus subjected to double taxation. And eventually and naturally, the effect of that is that it lowers your estate, the value of the estate. Okay, so these are realities that you need to consider when making your estate plan. Now, another factor is the appointment of your administrator and executor. Now, remember this, friends. These are positions of trust and competence. You need to find somebody who will not only be capable enough to implement your wishes, but persons who are of great integrity because they hold so much power over your estate. So the wise thing to do normally would be to appoint a group rather than just one person as trustee, or even consider the idea of appointing a corporate trustee. So these are ways by which you can protect your estate from unscrupulous individuals. Now, another factor is the nature of your assets. Now, sometimes in some countries, in most countries, there are some assets that are quite hard to transfer and expensive to transfer. So assets like real property and stocks normally would be more expensive to transfer as compared to cash. In the Philippines, for instance, when you transfer real property or stocks, you need to get BIR clearance. But if you want to transfer your account in the bank to somebody else, you can easily do that by making an amendment, signing some forms, and amending the owners by adding in a new owner or taking out another owner, assuming, of course, that such amendment is not because of death. So it's very easy when you're talking about cash. As a matter of fact, you can even write out a check to your beneficiary and nobody will know, right? So it's easier to transfer cash. And lastly, and just as important, are the personalities and needs of your heirs. While some heirs will follow your wishes, there are those who will challenge you in court. And this situation causes a lot of not just emotional, but even financial grief for the family. So all of these things must be carefully considered in any estate plan. Okay, now, let's talk about what the Philippine laws have to say on inheritance. And I will concentrate on two aspects, that pertaining to heirs and that pertaining to wills. Okay, so on the topic of heirs, there is what you call compulsory heirs and voluntary heirs. So compulsory heirs are persons who have the absolute right by law to inherit from you or a decedent being the person who dies. Whether you have a will or not, these people will inherit from you, and they are identifiable. You can identify them. Voluntary heirs, on the other hand, are persons designated via a will to inherit from the free portion of your estate. Okay, let me repeat that. Voluntary heirs are persons designated via a will who may inherit from the free portion of your estate. Okay, so they cannot exist unless you designate them via a will. Okay, now it's also important to note, one thing you also need to know about is the legitim. Okay, so the legitim is that part of the decedent's estate that he cannot dispose because it has been reserved for his compulsory heirs. Okay, the purpose of the legitim is to protect the surviving spouse and the children of the deceased. Okay, so the law already identifies that portion of your estate for your compulsory heirs. Next is, you need to understand as well that illegitimate children are heirs too. And by law, they are entitled to receive half of what a legitimate child receives. Okay. Now, the only way you can disinherit an heir is through a court proceeding. So hindi ho pwede yung, you cannot, I hope, not everyone understands Tagalog here or Filipino. No, you cannot just simply say, I will disinherit you. That has no power. Okay, so you need to, if you want to disinherit an heir, you have to go to court, and there are grounds that the court will recognize for this inheritance. Okay, later on, if you'd like to know, you can ask that in the Q&A portion. And then finally, also, if an heir passes before the estate owner, it is possible that his children may receive the portion allocated to him due to what is called the right of representation. So it does not mean that if one dies, that person is no longer entitled to get from your estate. Again, his children can take his place. Okay. Now let's go on the topic of wills. So what does the law, the Philippine law, say about wills? Okay, remember this. Even if you create a will, you can only dispose of the so-called free portion, while the rest has been allocated by law. So what really the will does is allow you to give beyond your compulsory heirs. So if you plan to give to a special, you want to give more to a compulsory heir, you need to do a will. If you want to give to somebody who is not a compulsory heir, you need to do a will. You want to give to your special advocacy, you want to your priest or your yaya, kailangan ho kayong gumawa ng will. Otherwise, hindi ho sila talaga mabibigyan, no? Kung wala kayong will. Now, wills require a court process called probate to become valid. Okay? So any distribution from a unprobated will can be invalidated. Okay? So probate is costly. Probate takes a long time. As a matter of fact, the quickest probate usually lasts at least a year. So when do you do probate? You can have your will probated. Most of the time, wills are probated after the death of the testator, but it is wise to have your will probated even while you are alive, so that you can still change and you can defend your will. Okay, so these are the important legal restrictions that you need to keep in mind while making your plan. Okay, I hope I'm not going too fast, but I'd like to be able to cram as much in this window that you are giving me. So now let's talk about taxes on your estate. Okay, let's get that all out. Now, with regard to local taxes that affect your estate, here are some points to remember. The estate tax is now at 6%. You know, that came from a high of 15% prior to train. So thank God, with the train, you really shouldn't be afraid to, there's not much erosion now that happens in the estate because the estate tax has been lowered to 6%. Now, for deaths prior to the Train Law, the estate tax, as I said, was a graduated table applied on the amount of the estate, depending on the amount of the estate. Now, remember this, the net estate is gross estate less estate obligations. And the gross estate does not necessarily include all that you own. It excludes accruals from SSS and proceeds from irrevocable life insurance policies. So if you want to create an instant estate, the best way to do that is to really get a life insurance policy. And even better is that proceeds from such are not subject to estate taxes. Now, estate obligations are claims against your estate, which such as loans, mortgages, and the like. Now, you have standard deductions on the estate. When you consolidate the estate, there are standard deductions amounting to 5 million plus an additional 10 million depending on the value of your home. Now, remember that the goal is to reduce the gross estate or increase the estate obligations to reduce the estate tax. So it takes a bit of creative accounting here. No? So you will need, many times you will need to jot down all your expenses, etc., etc., so you can maximize your estate deductions. There. Okay. Now, this is a guide for you. The computations can be complicated. You may need to hire an accountant to do this. But I've learned from friends that it's quite easy for as long as you have a clear mind and you have enough time. I think you can do it. You can do it also on your own. So now let's talk about, now your need for a professional will depend on how big or complex your estate is and how simple or complicated your wishes will be. Now, the kind of professional to consult will be determined by the different estate planning tools that you will employ in the crafting of your plan. In this next part of my discussion, I will briefly present some of the more popular estate planning tools, highlighting the benefits and the limitations of each tool, and dwelling a bit more on trust because that is my expertise. Okay, so let's begin. So what are some of the tools? There, some of the tools that you can consider when doing your estate plan. A durable power of attorney. I don't know if this is the first time you've heard of this, but there is what you call a special power of attorney. The difference with a durable power of attorney is that this one extends even beyond the principal's incapacity, medical incapacity. Okay, so at the most basic, okay, this allows someone else to manage your financial affairs if you are medically unable to do so. A special power of attorney does not do that. Normally, when the principal becomes incapacitated, the SPA also loses its power, but not a durable power of attorney. Your designated agent, as indicated in the document or directed in the document, can act on your behalf in legal and financial situations when you can. This includes paying your bills and taxes, as well as accessing and managing your assets. Now, remember this, though, that the power of the agent is revoked upon the death of the principal. And like I said, no, this is also a position of trust and power, so it is very it may be subject to abuses. So it is very important that you choose the right person to give this power to. So that's the durable power of attorney. Now, there is, of course, life insurance. Very popular. It has played a very critical role in estate planning, providing a source of liquidity to pay estate taxes and other expenses. You know, too often we have heard about families who have resorted to selling assets at a sacrifice in order to pay for their estate obligations, because such should be paid within 1 year from the death of the estate owner. Also, now, other than providing for liquidity, life insurance can also be a means can be utilized to achieve estate equalization. The best way to explain this is through an example. So assuming that I have a business, very successful, and I have 2 children, One child works in the business, very passionate about it, very good at making it grow. And the other child doesn't care, decides to live his life abroad, doesn't want to have anything to do with the business. Now, naturally, it would not be right to give him a share in the business. So what you do is you leave your business to the son who loves it and take out an insurance policy with a value equal to the size of the business, and name your other child, the one who is not interested, as the beneficiary to the policy. So when you die, he gets his cash and your business goes to your son who loves it. Okay, so that's one way to achieve. This is what we mean by estate equalization. Okay, now the problem with life insurance is that it has no management mechanism for the proceeds. I've actually seen families come into come into possession of a huge amount of money from an insurance policy, and because they do not have any know-how, as to in terms of managing such assets, they squander the proceeds away. So very, very sad, very sad. So and also, if your beneficiaries are minors, the problem is the money will go to their guardian, and at that point, really, who will check whether the funds will be utilized really for the beneficiaries? So that is the problem with life insurance. Okay. Next, we go to a third tool, which is family corporations. Very popular because especially very effective when you want to lower estate taxes. Because, friends, you see, the transfer of assets to a corporation where the transferor gains control is tax-free. So you can actually transfer all your assets into a corporation and not pay taxes on that, provided you end up to be majority owner of the corporation. Now, the heirs of such shares would then pay taxes based on the book value of the shares rather than the actual value of the property. And this is where the savings really happens. Okay. Now, there's also continuity in the management of your business for the heirs, because for as long as they are stakeholders, they can immediately take over once you die. So it's easily transferred, and the stockholder's liability is limited by his ownership in the corporation. And again, perpetuity of ownership in the hands of the heirs may be assured. So let's say you have a family home or several properties that you are sentimental about. The best way probably is to put it inside a corporation so that no one heir can just easily sell it off. Okay. So, but the limitations are also there, as you can see on screen. Maintaining a corporation can be very taxing, can be very costly. There are regular repertorial requirements for corporations. They do not really eliminate taxes, but only defer its payment. And of course, it could invite sibling jealousy and problems for succession, especially in cases where there are heirs who are working in the business and heirs that are not. Okay, so these are family corporations. I think this is one of the more popular ways that individuals do estate planning. But again, it's not always the best way. I've met an estate planner, estate owner once, who was so proud that he made a corporation. And when I asked him where his children were, all of them were all abroad and they have no interest in returning to the Philippines. So I said, sir, at the end of the day, when they come back, they will just sell that. They will just disband the corporation and sell everything. So again, you have to take into consideration the situation and the desires also of your heirs. Okay. The next tool is the use of wills and testaments. So it's commonly known as last will and testament. So when you do a last will and testament, you you clearly earmark properties to heirs to avoid controversy. Now, remember that the transfer under a will happens upon death of the testator. So really, there is no transfer yet upon the crafting of the will. The owner retains control until his death. The owner can also set conditions before the heir gets properties, and it gives him flexibility to change his mind along the way. Now, in your will, you can name who receives your property, your children's guardians, and an executor to oversee the probate process. It can likewise contain provisions on end-of-life care, where one can specify desires regarding life-prolonging measures if there is no hope of recovery. But then again, as you can see, there are also a couple of limitations, probate being one of them, costly, very public. It can be a long and tedious process. In the meantime, while the will is undergoing probate, the assets are frozen, and many times it is made, the affairs of the family are made public. So there's very little privacy when you do a will and have it probated. Okay. Now, the next tool is inter vivos gifts or donations. Inter vivos to mean those done within the lifetime of the giver and the receiver. Okay. So because it's a donation, it's already removed from the taxable estate of the testator. It identifies immediately the recipient and reduces the possibility of fighting over specific properties. And donations inter vivos may be cheaper as the taxes are based on the value of the asset, during its transfer. Okay. So it's especially useful because anything that you give away, again, like I said, no longer forms part of your estate, and it has proven to be cheaper. However, the limitations, as you can see, these are glaring limitations that not a lot of people know. Property donated to unmarried children become part of the community property upon marriage. So I always tell this to my clients, even in donating, there is a perfect time and place for it. It does not ensure proper management. When you give and donate, naturally, the recipient possesses immediately the donation, and you cannot be assured that the beneficiary will be able to manage well the donation given to him. Now, while it anticipates the giving, it also accelerates family squabbles. Okay, so that's in inter vivos gifts and donations. And finally, last but not the least, is the use of an irrevocable trust. So irrevocable trust, to be more specific. On screen, you will see the benefits. I think most of you are trust practitioners in the room. So a trust is a legal structure that allows a grantor, also known as the trustor, to earmark assets to his beneficiaries, thereby protecting the assets from creditor garnishment. Just like, think when you talk about irrevocable trust, think donation. The difference, though, is that instead of the asset going directly to the beneficiary, it is reposited to a trustee who takes care of the asset, makes it grow, and disburses it according to a plan or according to the wishes of the grantor. So here, the trustor defines the purpose for the trust and the manner by which the assets are to be distributed to the beneficiaries. And again, because the trustee or the arrangement, the structure, can have or has an investment management mechanism which allows for its further growth, as the trustee may be authorized to invest the funds. Okay. However, in terms of limitations, institutional trustees such as banks would normally avoid the management of non-cash assets. They are extremely regulated by the BSP. And like I mentioned, because under a trust, there has to be a purpose, and all drawings from the trust have to be consistent with the purpose. Withdrawals from the trust should always be consistent to that. And sometimes evidence will be such withdrawals or such disbursements may have to be evidenced by documentation. Okay. So, in closing, having a legacy estate plan buys peace of mind for you and your family. Remember that the best plan must protect people over assets. Give your heirs as much attention and time as all the other parts of estate planning, probably even more, because an estate is tied to people and families. Incorporate your values in your plan. Tell them about your expectations and your wishes, about how they should behave with regard to each other. Too often, we've seen estates laid to waste because of fighting within the family. The surest way to keep your heirs, to help your heirs avoid trouble, is to educate them and to talk to them about their responsibilities. Finally, keep your plan up to date. Setting up your estate plan is only half the process. Like any other area of like other areas of financial planning, your estate plan should evolve. As life changes, your assets, beneficiaries, and wishes can also change. It's a good idea to review your estate plan regularly or at key life events such as marriage, the birth of a child, divorce, the purchase of a really expensive asset, retirement, or the onset of illness. So these are just a few of the milestones that you may consider when deciding to review your estate plan. So in ending, estate planning is not about planning for your death, but it is planning for you and your family's life and future. So friends, anytime soon is a good time to start. Thank you and good afternoon.
All right. Thank you for that, Ms. Wanda. We'll proceed to the Q&A section of this webinar. For everyone, please write your comments or questions to the speaker in the public chat space. You may also raise your hand in the Zoom call as well, and we can call you about that. So while we wait for, there you go. So while we wait for questions to come in, I'll field my first question about it. A lot of us in the call at least are analysts and those who, of course, were connected to the CFA program, of course, in different stages. Per your opinion, because while we were listening to this webinar, there are a lot of like legal questions. There's a lot of knowledge that has to do with the legal profession laws. How would you divide, for example, your time? If you're a budding analyst, how would you divide it between learning the necessary laws and perhaps hiring experts to guide you about these laws? How would you personally recommend that? Do you need to learn all of the laws about estate planning?
Well, you know, there are only a few laws that impact the estate, that impact estate planning. As a matter of fact, I'm not a lawyer, but as you can see, my grasp of the laws that affect estate planning are quite clear, no, and I would say useful to me. So how do you divide your time? I think you know, attending seminars like this, joining, reading through case studies about estate planning can already be of help, can already help you understand it. When it comes to understanding, when it comes to the law, I think what's important is knowing, you know, about taxes, transfer taxes, the impact of transfer taxes, because really that is the heart of estate planning, no? And that's just and that's a portion only of the tax laws, no? And then there's property regimes, knowing the property regimes, especially when talking about married individuals, you know, what is the what is the right of a compulsory heir or a surviving spouse insofar as the total the total property community of the marriage. So I think you don't necessarily need to go to law school to know these things. Directed courses can already help you have a good grasp of laws and issues that you need to understand when making a plan.
Thank you for that. That I think would be very helpful to a lot of our audience here. Let's take a few of the questions. We see a few coming in. Let's start with SECB Brett, SECB Brett. Thank you for this. He's asking about unlisted shares. Are there any tax implications of if you transfer irrevocably unlisted shares to a trust account?
Yes, like I said, shares of stock, whether listed or unlisted, will have to get BIR clearance. So you need to have an e-CAR prior to the transfer of such assets. Now, I think the challenge there is determining the value of unlisted shares. And this is where the BIR can get creative, no? Many times they will ask for an appraisal, they will ask for the FS. So you will need to make sure that when you go to the BIR and apply for a clearance or the payment of the donor's tax, or so that you can get the e-CAR, the information can be readily available. Each BIR will have a different way of valuing assets, unfortunately. No, meron hong batas, pero magugulat ho kayo kasi depende ho sa RDO na kausap ninyo. Minsan, a real property they will treat as an ordinary asset. Sometimes naman they will agree that it's a capital asset. Take an asset that is lodged inside a trust. Per practice, assets that are lodged within a trust arrangement or a trust structure should be treated as capital asset. But you will be surprised. Some revenue district offices treat it as an ordinary asset, especially when they dig deep into the personality of the beneficial owner or the trustor. Okay, so again, you need an e-CAR, you need an e-CAR to transfer unlisted shares. The challenge is determining the value of those shares, and the BIR will be able to give you direction or guidance on that.
Mm-hmm. Thank you for that. So I guess it depends on the specific RDO you're speaking with. Let's take another question. I see, thank you to Edgar Lai from St. Peter Life Plan. He's asking about the benefits of gifting and donation, especially if you consider that both estate and gift taxes are the same, and then bigger deductions apply to the former. What's the benefit? I guess besides from cheaper asset values.
Yeah. Well, okay. Okay, honestly, for me, it's really about securing assets for your beneficiaries already. So when you donate, okay. So let me qualify that response. Okay. Sometimes donations can help you give more to non-compulsory heirs, or sometimes even to a compulsory heir. So I think if the objective is to give to people outside your compulsory list, a donation is really the best way to do it. Okay. If the intention is also to give more to a special child, then a donation is the best tool to do so. Next, if you want to give to, for example, I've come across estate owners who want to leave behind something to their grandchildren. So really, your grandchildren are not part of your compulsory list, heirs list. So the way that I would always tell my clients, what I would always tell my clients is that if you want to give to your grandchildren, do a donation. And because their parents, your children, will receive the donation on their behalf, they will not contest it when the time comes. So these are just a few of the reasons why a donation makes sense.
All right, thank you for that. Very interesting cases, of course. Let's take a couple of questions from Ms. Chris Arceo. Welcome to the webinar. Do you know what rate is applied to an heirs bond and where is it based? And also, can you elaborate on the free portion of the estate?
Okay. Heirs bond, unfortunately, I'm not so familiar. But yeah, I'm not familiar with how an heirs bond is put up, the amount that is required to put up an heirs bond. I cannot answer that, but I can get back to you later. So in terms of the free portion, normally if you the free portion is normally equal to the share of the share of a compulsory heir. Okay, so that is the amount that you can give away to non-compulsory heirs. Let me give some examples. Hold on. Okay, so assuming that let's say that you die and you have 2 children and a wife, and you die with a will. Okay, so the 2 children and a wife, your legitimate child 1 will get 1/4 of the estate. Legitimate child 2 will get 1/4 again of the estate. Your spouse will also get 1/4. Okay, and finally, if you do a will, the remaining 1/4 you can give away as free portion. So that's how it's computed. Okay, so now as you have more beneficiaries, the free portion actually gets bigger, and I really don't understand why. I've never, I don't dwell in this. I leave the lawyers to discuss this, but essentially that's how it's done.
Okay,
so
it's
by the way,
basically-
guys, maybe just as a food for thought, so when a person dies and that person is married, so the estate is collated, and half of the estate is actually the share of the surviving spouse. So that is not part of what is distributed. So 50% is set aside because that is the share of the surviving spouse. And the remaining 50% becomes the whole pie, which is then divided across his compulsory heirs, the spouse included. Okay, just to clarify.
All right, that's an interesting I guess decision, isn't it, as to what free portion becomes. I guess let's get a question related to that. Thank you to Enrique Fausto. Do you have any courses or programs in mind that you would recommend? Like, say, if you want to learn more about estate planning as a wealth advisor, maybe you have a recommended course.
There is a course run by the Wealth Management Center. Wow, that's free plug. A course run by the Wealth Management Center. I think this is you take three modules, one of which is estate planning, and you become a certified wealth planner. That's probably something that you can consider to know more about estate planning.
Yeah, thank you for that. We'll definitely check it out after. Let's take the next question. Thank you to Rob Kumalik from Security Bank Trust. You mentioned that one of the benefits of establishing an irrevocable trust is to prevent creditor garnishment. Can you elaborate further, maybe a couple of sentences on it? Like, does it refer to the legal title being transferred to the trustee? Thus the creditor is prevented from claiming? Are there exceptions? Perhaps is a court order an exception?
Okay. When we talk about garnishment, we are very specific. This is creditor garnishment. So there are other types of garnishment. those pertaining to what do you call this? Some some other form of garnishment, like the right probably of a wife who is a spouse who is claiming, etc. But we're specific about creditor garnishment. So the reason why it's out of reach from the creditors is because technically the assets are no longer owned by the grantor. So you cannot get that which you cannot give that which you do not own. So that is the reason why it is out of reach of credit.
Are there exceptions? Are there court orders that are exceptions to this, or is that?
Again, creditor garnishment. So if you have a case where it's not really that challenged, except if the trust is designed such that the grantor is also a beneficiary of the trust. So that can be challenged because eventually the trust, the right or the benefit of the trust accrues also to the one who sets it up. So in that way, it's his also. So that one I think can be taken if just logically thinking about it.
Okay,
but so far in my life as a practitioner, I have not had a creditor garnish a trust account. I don't know with you guys, but whenever there is an order for garnishment that comes to the bank, and it of course it's broadcasted across the bank, even to the trust department, all our response is there's nothing that can be garnished, and they take it as is.
Okay, definitely understandable. Thank you for that clarity. Let's take another question from Ms. Chris. When assets are transferred to an irrevocable trust, I guess, are there taxes that need to be paid?
Yes, okay. The way to operationalize an irrevocable trust is to go through a donation. I do not know how other institutions do this. I guess I'm sharing secrets now. But really, that's how it's done. When you set up an irrevocable trust, you go through the motions of a donation, because the BIR does not recognize or is not familiar with how an irrevocable trust works. They only are familiar with a donation, and the tax laws only account for taxes on donations. So you have to go through a donation. You execute a deed of donation, but in the deed of donation, instead of the donation going directly to the donee, it goes into a trust account that is set up on his behalf. So that's how the deed of donation is worded. So yes, there are taxes involved. There are donors' taxes will need to be paid upon the setting up of a irrevocable trust.
All right, thank you for that. Let's get another question from Enrique Fausto. Speaking of bank trust departments, what do you think is like the size of an estate that makes sense to engage a bank trust department in terms of estate planning? Is there like a size that you would recommend? Yeah.
Yes. Actually, the size is really dependent on the bank. Because if you think about it, when you take on the role of trustee, you actually commit to protect the estate. You commit to see to its distribution from womb to tomb. No, and most banks will not will not consider doing that business unless it is for a sizable amount of estate. For I think, okay, like I said, if you have assets and you have beneficiaries, estate planning is necessary. Now, as to engaging a corporate trustee, most banks will probably ask you an amount of maybe 20 million and above before they can offer this service to you.
Okay, that sounds like a good benchmark, I think, the 20 million amount. Of course, I guess it will depend on the bank as well. So contact your bank accordingly, I suppose. And there's one more question in the chat. So for everyone who has questions, feel free to share them as well. Let's take the question from Carl C. His question is about unmarried persons. The general question is, how is their assets distributed, or are there any special considerations?
Okay. For Okay, even single persons have compulsory heirs. Okay,
Mm.
so normally your heirs, they flow like a river. Your compulsory heirs, the assignment of compulsory heirs flow like a river, first downwards, then upwards. If you are single and your parents are still alive, then they are your compulsory heirs. Now, if they are no longer alive, then you may consider as heirs, legal heirs, whether they are compulsory or not. I think they can be made compulsory, your siblings. So it flows like a river, first downwards. So if you are married, your wife, your spouse, and your children, then upwards, your parents, and then sideways to your siblings.
All right, definitely. I guess everyone would that be accurate to say that generally everyone has, by definition, a compulsory heir?
Yes, I think so. Yes.
Okay. All right. There you go. Someone someone like that answer. So it applies to singles like them as well. Well, this is an interesting question. I'm not gonna delve further, but in terms of like will creation, can they remove siblings or perhaps people in general? Is that an option?
Okay. When you make a will and you disenfranchise a compulsory heir, of course, the courts will invalidate that. Again, the determinant there is whether there are compulsory heirs that you are you're not including in the will. So that will be a problem. Yeah, so that's really the case. Can you not include a sibling? I think yes, you can disregard a sibling if you're single. If you have a parent still, then you can definitely disregard a sibling because the parent is in the hierarchy of heirs. He takes precedence over the sibling. Now, if you don't want to do a sibling, then I would suggest that you make a donation before you die. So that when you die, you don't own anything. And they will not be interested to get anything from you. By the way, you can you can actually set up or you can just set up a trust for yourself to pay for what you need, or you can design a trust such that you donate it, but the fruits of the trust, let's say an irrevocable trust, you donate it to a cause or to a beneficiary, but the benefits or the fruits of the trust you can earmark for yourself. I think that can be done.
Okay. And to clarify, I think another question came in. For married persons, since we're talking about siblings and parents as well, do parents and siblings of married people still count towards the list of compulsory heirs?
No.
Not anymore.
Not
So if you
anymore.
want to give to them, it's through donations, I suppose, or
making a will, and you
or
give
making
them
a will.
a free portion. Yes.
Okay. So that's good. We see a lot of good responses in the chat. Maybe we'll get this as a last question. It's more like how do we like convince other people that we know to think about estate planning like in front of their minds? Because do you find that it's difficult to have people think about like there's circumstances after death, or what's your experience there?
Normally, conversations to jumpstart estate planning are very mundane. You go to a friend and you talk about what you own, how many
Yes.
properties you bought, and then you ask them, have you planned how this will pass on? Pass on to your heirs. Have you designed something so that your husband will know that you have this, you have that? When we go out on trips, do you actually endorse your insurance plans to your parents so that just in case something happens to you, they will collect on it? So these are very mundane concerns that you can bring into conversations with your friends and your family and and your clients. That your client has a special child. You talk about how do you plan to provide for the child when you're gone. You bring those conversations, and really it borders on concern, and that is how that is my style. I guess as a practitioner, that has been my style in bringing across the advocacy of estate planning to my clients. And many times they have appreciated this approach, because they see that ultimately at the end of the day, I am not just concerned with them, but also with the people that they love.
Mhm. So definitely approaching it through concern is probably one of the
Yes.
best.
If you know, every situation can have an angle to bring in estate planning. When you've been purchasing real property, when suddenly you are sick, you have a health scare. So these are situations in your life where, you know, the idea of an estate plan or a will becomes important. I think we only have to look at the experience of COVID to know that a lot of people were unprepared during that time, and to the detriment of families, you know, not knowing where to get money, not knowing what actually their family member, their sick family member, has left behind, etc. So I think with the pandemic that has happened, people are now more conscious about planning and planning for their transfer and wealth consolidation.
Right. And I think that's a good way to end this section, the Q&A section. Thank you again, Ms. Wanda, for enlightening us on estate planning, as well as giving us specific answers, as well as providing us with the encouragement to discuss this as well with everyone else.
Thank you very
So
much.
to our participants, please turn your attention to the screen for the QR code of our online evaluation. Please take the time to answer the survey. It will take you perhaps 1 to 2 minutes to complete. So I'll give everyone around a minute or so to complete that. Ms. Wanda, I guess at this point, any final words to everyone in the call?
Well, first, I'd like to extend my gratitude to the CFA Society for doing this. I know it is probably not very a common topic to analysts like yourselves, but it's good to know that there is interest out there. If you need help to understand more how this is done, or even probably have clients that you'd like to refer, or cases that you'd like to discuss, please feel free to reach out, and I will be very happy to be of help. Again, thank you very much and good afternoon.
Yeah, thank you for that. Please stay so we can have the photo opportunity with you as our guest speaker. So hopefully everyone has taken the time. For everyone, let's turn on our videos for the photo op with our guest speaker for today. Let us know, Precious, if you've done so.
Okay, 1, 2.